This film is a project of the Leonore Annenberg Institute for Civics at the Annenberg Public Policy Center of the University of Pennsylvania. There are three branches of government. Congress writes the law, the executive enforces the law, and the judicial interprets the law.
The Supreme Court isn't allowed to look at what popular opinion might be. They really are interpreting the law as they see it.
But what if the court interprets a law and the people don't see it that way? That's the story of one 70-year-old grandmother from Alabama who lost in one branch, then won in another. Gadsden, Alabama is home of the Nakalula Falls and the Broad Street Bridge. It's just about an hour north of the Talladega Superspeedway. And in 1979, if you were looking for a job in Gadsden, the place to start was the Goodyear Tire Company. You know.
The rubber company. People with a blimp.
And looking for a new job was Lily Ledbetter.
People make funny comments about my name.
Lily Ledbetter was already a manager at an accounting firm when she decided she wasn't living her dream and it was time, well, for the rubber to meet the road. You see, Lily loved radial tires.
My father had been a mechanic all his life, and I just knew that radial tires were the way of the future.
She wanted to secure her own future, so she landed a job at Goodyear.
And I was hired in February 5th, 1979.
Lily Ledbetter worked at the Gadsden plant as an area manager for 19 years. She did the overnight shift for a good period of that time, and for many years she was the only woman holding that job.
The men did not appreciate a woman being in a position that could tell them what to do.
This flat tire needs a man, but when there's no man around.
Look at this. This is an actual commercial that ran during Monday Night Football just a few years before Lily was hired.
When there's no man around, Goodyear should be.
Okay, times were a little different, but Lily knew what she was up against and still did her job well. For almost 20 years, Lily managed the men who worked for her, won honors for her management skills, and supervised the making of tons, literally tons, of radial tires. Still, week by week, tire by tire, Lily didn't know it, but she was falling farther and farther behind the men in pay.
At Goodyear, I was told when I hired in, you never discuss your pay with anyone.
Like many companies, Goodyear had a pay confidentiality policy. They did not share pay information with other workers.
Employers want pay to be secret because they don't want employees to be jealous of one another or resentful of what other people get paid. And so the problem that Lily Ledbetter faced is a very common problem with respect to pay, which is that you may well be the victim of discrimination and yet not know it.
For years, Lily got checks every payday just like the other employees. She got raises on a regular basis. It all felt normal, but
she heard rumors about what other people were paid. She had some suspicions based on little pieces of information she picked up here and there.
And then one night, just before she was about to retire, Lily found out the rumors were true when she came into work.
And I reach into my little cubby hole where I call a mailbox at work, and I drag out my mail, and in that is a torn, rough square of paper. And I looked at it. I saw 4 first names. I saw the base salaries. I knew it was true because mine was correct, $3,727 base salary per month. I was devastated.
Lily decided to sue Goodyear.
There was no one else close to what I was being paid with my track record and my length of service. A guy may be making $60 an hour where I'm still only making $30. Now, if that's not discrimination, I don't know what it is.
Now, there has always been a gap in the wages that men and women are paid, always. And the wage gap is still huge today.
Well, a wage gap is where men and women do the exact same job, the exact same hours, and they're not paid the same amount. So nationally, women make about 77 cents on the dollar that men make.
You can really start a debate among social scientists about that question. Why do women earn less? You can try to account for everything you can think of: education, experience, job category.
It's not because they're home taking care of family. This is across the board that women don't earn as much as men.
It sounds just totally and patently unfair, and it is.
The gap in Lily's pay was even greater than the normal wage gap. Lily was only making as little as 60 cents for every dollar the men in her position made. That's up to 40% less. Think about it this way. After being paid less money each week for over 19 years, Lily ended up making hundreds of thousands of dollars less than the men. The jury in Lily's case awarded her over $3 million.
The jury in Lily Ledbetter's case clearly felt that Goodyear had acted egregiously. The $3 million number is a very high number for this sort of a case.
I just wanted to stand up and shout and thank them and thank them.
But the law limits the amount a jury can award someone in a case like this to $300,000 plus 2 years of salary at a non-discriminatory rate. So the judge reduced Lily's award from over $3.5 million down to $360,000. It was still a victory for Lily. Then Goodyear appealed.
Here's where it gets complicated. So Lily Ledbetter wins this great jury verdict. And then something happened to completely unsettle the case.
The 11th Circuit Court of Appeals ruled in Goodyear's favor. But the Court of Appeals didn't rule that Goodyear was not liable. It ruled that Lily missed the 180-day filing deadline.
The 11th Circuit came back and said that I should have filed within 180 days when my pay was initially set, that I definitely had a discrimination case. I was too late in my filing.
There are good reasons in the law for having your finality and for having deadlines. If you're running a business, you might know that there's a certain period in which you risk a lawsuit, but you shouldn't have to worry about it for 30 years.
Sounds reasonable, but here's where the courts come in. What exactly does 180 days mean?
That is plenty of time to file a charge once you know, but if you don't know, you can't do anything about it.
Is it 180 days from the day the decision was made to discriminate, even if the victim didn't know about the discrimination? Or is it 180 days from the check that comes after the victim finds out? Congress passed two main federal laws to ensure women are treated fairly on the job. The Equal Pay Act specifically called for men and women doing exactly the same job to get equal pay. It was passed by Congress in 1963 and signed by President John F. Kennedy.
I must say I am a strong believer in equal pay for equal work, and I think that we ought to do better than we're doing.
And the following year after President Kennedy's assassination, Congress passed the Civil Rights Act of 1964, signed by President Lyndon Johnson. Martin Luther King Jr. and other civil rights leaders fought for this law, which dealt with everything from voter protection to desegregating public spaces. Among its key provisions or titles is Title VII.
Title VII is one of our most important civil rights statutes that governs employment discrimination in the workplace. It makes it unlawful to discriminate against employees based on race, sex, color, religion, and national origin, and it is probably our single most important civil rights statute when it comes to ensuring equal opportunity in the area that hits people the hardest, the workplace.
It received the bipartisan support of more than 2/3 of the members of both the House and the Senate. An overwhelming majority of Republicans, as well as Democrats, voted for it.
This is representative government. Congress and the presidents who signed these laws were responding to concerns voiced by their constituents.
The civil rights statutes were the result of many years of civil rights protests and demonstrations. It's really about the responsiveness of the American political system to the will of the people.
Congress over the years has acknowledged workplace inequality as a major social problem, a problem that interferes with everyone's ability to compete on equal terms.
The purpose of the law was to stop people from being paid unequally.
And since 1964, appellate courts had all ruled that a suit could be filed 180 days after the victim received a discriminatory paycheck, even if that check came years after the discrimination began, because a victim might not know she was a victim until she found out what everyone else was paid.
That rule we call the paycheck accrual rule. And under the paycheck accrual rule, every time the employer writes out a discriminatory paycheck, the statute of limitations starts over.
But this type of case had never made it as high as the Supreme Court. So when the appeals court in the Ledbetter case disagreed with all the other courts before it, the Supreme Court decided to step in. This case was no longer about discrimination.
The jury verdict was never overturned.
The jury found that she had proven her case. She faced discrimination.
By the time it got to the Supreme Court, the Ledbetter case was about how to interpret the statute of limitations in Title VII.
The question that went to the Supreme Court was, when does the 180 days start to run? What Goodyear said was, it doesn't matter whether we paid her less because she was a woman or not, because this happened too long ago. So she simply filed her claim too late.
What Ledbetter was arguing is that her 180 days would reset each time she got a paycheck that paid her an unfair amount.
Now, there are other films that tell that rare, very American story of an average, everyday person taking their case all the way to the Supreme Court and winning. This isn't one of those. Lily lost.
The majority opinion for the court adopted Goodyear's arguments and the 11th Circuit ruling that the discriminatory act that starts the clock ticking is the intentional decision itself to pay someone less because of their sex, not the receipt of a discriminatory paycheck.
It was a 5-4 majority opinion written by Justice Samuel Alito that said the injured party should have 180 days to sue, starting from the time that the decision to discriminate was made. After that, Justice Alito argued, the statute of limitations should be enforced.
Justice Alito agreed with Goodyear.
That day, Justice Alito read the decision from the bench.
An EEOC charge must be filed within 180 days of the unlawful employment decision itself, even if its effects are not felt until later.
When Justice Alito was done,
we therefore affirm the judgment of the 11th Circuit.
A conflict between the justices was about to become a conflict between the three branches of the federal government.
Justice Ginsburg has filed a dissenting opinion.
When the Ledbetter case came to the Supreme Court, there was only one female justice on the court, Justice Ruth Bader Ginsburg.
Justice Ginsburg was the leading litigator on sex discrimination cases in the United States.
Justice Ruth Bader Ginsburg was the first woman to make law review at both Columbia and Harvard. She wrote the first legal textbook on sex discrimination cases. So when she took the unusual step of reading her dissent from the bench in the Ledbetter case, everyone understood the significance of the moment.
It's very unusual for justices to read from the bench when a decision is announced. They want to make a point.
When a Supreme Court justice decides to read a dissenting opinion from the bench of the Supreme Court, she's forcefully disagreeing.
She said that the majority got this issue completely wrong.
Title VII was meant to govern real-world employment practices, and that world is what the court ignores today.
Quietly, calmly, Justice Ginsburg read a summary of her dissent.
Comparative pay information is not routinely communicated to employees. Instead, it is often hidden from the employee's view.
And before Justice Ginsburg finishes, there's something I need to tell you. Back in 1991, after the court had handed down some decisions interpreting the Civil Rights Act in a way that Congress thought did it harm, Congress changed the law, basically telling the court, we didn't like your interpretation.
The yeas are 381, the nays are 38. The Civil Rights Act of 1991 is passed.
With that in mind, Justice Ginsburg ended her dissent in Ledbetter with this.
Today, the ball again lies in Congress's court. As in 1991, the legislature has cause to note and to correct this court's parsimonious reading of Title VII.
Justice Ginsburg called on Congress to change the law so that the Supreme Court's decision wouldn't stand.
Remarkably, Justice Ginsburg in her dissent goes so far as to say the ball is in Congress's court.
Justice Ruth Bader Ginsburg challenged Congress to change the law back.
Because this is not a constitutional case, it's a statutory case, Congress can go back and fix it.
Here's the deal. There are really two types of Supreme Court decisions. One is constitutional. The court has to go all the way back to a provision in the Constitution to determine the outcome of the case.
If the Supreme Court interprets a constitutional provision, the Supreme Court essentially has the final say, unless the Constitution itself is amended.
Which is a very cumbersome process. It doesn't happen very often. It takes a supermajority at many levels to amend the Constitution.
But sometimes the court is handing down a ruling that is interpreting or clearing up some confusion over a statute written by Congress. And that's a statutory decision.
No law can anticipate every possibility or every eventuality or every case that may come up, and therefore courts always have to interpret laws and said, what did they mean?
In this case, at what point do you start counting 180 days?
That's a question not of constitutionality, but of how do you interpret what Congress said.
The separation of powers doesn't just allow the three branches of the federal government to check and balance each other's power. That's what they're supposed to do. But it's not a street fight. They have to do it carefully.
I think the relationships between the branches can be described as cordial but cautious.
You have to be prudent, and you have to weigh all kinds of important factors. And so you have to think about the precedent that's creating for your successors and whether you exercise a certain amount of restraint.
And what Justice Ginsburg is doing is engaging in a conversation with the other branches.
A big function of the courts is to interpret the meaning and application of a statute. But that's not the end of the dialogue.
So when Justice Ginsburg called on Congress to overturn the Ledbetter decision,
the ball again lies in Congress's court.
She believed the Supreme Court was interpreting the law in a way that Congress never intended, and she challenged Congress to fix it. And the person who picked up that challenge was Lilly Ledbetter.
When the ball left the Supreme Court and bounced into Congress's court, Lilly went with it.
So Lilly took her newly famous name and her cause across the street to the Capitol. She testified at hearings.
I hope that this committee and the Congress as a whole can do whatever is necessary to make sure that in the future, what happened to me does not happen to other people who suffer discrimination like I did.
She put pressure on Congress, making her argument in the media.
I would get up at 4 a.m. and do call-in radio programs. When you go in and you're learning a new job, you don't think about checking to see if you're being paid less because you are a minority or a woman. I was still trying to learn where all the restrooms were.
Campaigning for her cause landed her on the campaign trail. She even spoke at a national convention.
This isn't a Democratic or Republican issue. It's a fairness issue.
That's part of the art of our system, is that where you fail in the judicial branch, you still have another avenue available to you.
In fact, Lilly was no longer fighting for herself. Losing her case at the Supreme Court meant that she could never recover her jury damages. Even her pension, which was based on the unfairly low salary she'd been paid all those years, would stay unfairly low. Any law that Congress might pass would only help future cases, not Lilly.
She became the spokesperson because she didn't want this to happen to anyone else. She didn't stand to gain from it.
There was never going to be any money for her. Her injustice was never going to be righted, and she knew that. And yet, despite that, she was willing to fight hard on behalf of all of the other women who still had an opportunity to be treated equally.
In January 2009, nearly 2 years after the Supreme Court decision, Congress passed a bill in response.
The language of the act, which is quite short, is clearly directed at the ruling in the Ledbetter case.
This was against the clear will of Congress,
The statute of limitations for an equal pay lawsuit now resets with each discriminatory paycheck. After a decade of fighting, Lilly Ledbetter had gone from the Gadsden plant to the Supreme Court to Congress to this.
Ladies and gentlemen, the President of the United States, accompanied by Mrs. Lilly Ledbetter.
The first bill the new president signed into law was the Lilly Ledbetter Fair Pay Act.
The Lilly Ledbetter Fair Pay Act. I had always had people make funny comments about my name, like it belonged on the Beverly Hillbillies, but now I sort of like it.
This is a wonderful day. Lilly could have accepted her lot and moved on. She could have decided that it wasn't worth the hassle and the harassment that would inevitably come with speaking up for what she deserved. But instead, she decided that there was a principle at stake, something worth fighting for.
Lilly Ledbetter lost the battle but won the war.
The enactment of the Lilly Ledbetter law tells the people that political activism and engagement is an essential part of our political process, and that individual citizens should not believe that they don't have the authority and the capacity to bring about changes in the law.
I think that Lilly Ledbetter is really the quintessential symbol of how one person can make a difference.
If someone had asked me some years ago, I would have not believed one individual could start such a movement that would gain so much support across the country. If an individual believes and got the grit that it takes, they can stand up and continue fighting and make a difference.